to firstly consider whether there is any evidence led by the prosecution that shows that a crime alleged has been committed by the accused. That test requires an analysis of the evidence led by the prosecution and consideration of the elements of the offense in a bid to determine whether an offense known to law is committed. Having considered the totality of the evidence, to firstly consider whether there is any evidence led by the prosecution that shows that a crime alleged has been committed by the accused. That test requires an analysis of the evidence led by the prosecution and consideration of the elements of the offense in a bid to determine whether an offense known to law is committed. Having considered the totality of the evidence, to firstly consider whether there is any evidence led by the prosecution that shows that a crime alleged has been committed by the accused. That test requires an analysis of the evidence led by the prosecution and consideration of the elements of the offense in a bid to determine whether an offense known to law is committed. Having considered the totality of the evidence, to firstly consider whether there is any evidence led by the prosecution that shows that a crime alleged has been committed by the accused. That test requires an analysis of the evidence led by the prosecution and consideration of the elements of the offense in a bid to determine whether an offense known to law is committed. Having considered the totality of the evidence, to firstly consider whether there is any evidence led by the prosecution that shows that a crime alleged has been committed by the accused. That test requires an analysis of the evidence led by the prosecution and consideration of the elements of the offense in a bid to determine whether an offense known to law submission by the first accused is overruled and agreed to put his defense to the charges that he faces. I deal with the second accused. With respect to the second accused, counsel for him submitted that he is charged with 4 counts of offences on the amended indictment, and counsel submitted that he was appointed on the 6th of June 2016 as Ambassador Extraordinary and Permanent Representative to the United Nations in New York. He however assumed duties on the 6th of September 2016 and presented his letters of credence to the UN Secretary General on the 9th of September 2016. Counsel argued that the second accused did not participate in any of the contract procurement processes, including the award of contract to the contractors, Fairfield Construction. All of the respective processes were carried out while he was at the material time serving as the ambassador of the Republic of Sierra Leone to the Republics of Guinea, with accreditation to Guinea-Bissau, Cape Verde, Mali, and Niger, with residence in Conakry. Counsel argued that but for the erstwhile Director General of Foreign Affairs memo of the 6th of December 2016, as shown in Exhibit AQ-124, the second accused will not have signed the contract by reason of the fact that as political head of the mission, he was neither a member of the Procurement Committee or unit of the Ministry of Foreign Affairs, nor a member of the Procurement Committee or unit of the Sierra Leone Permanent Mission for the purposes of Section 18 and 19 of the Public Procurement Act of 2016. Counsel further argued that the action of the second accused was not willful or negligent. And with respect to the memo, he argued that the second accused was not accorded a supervisory role in the contract implementation or control over the rehabilitation of the chance-building funds. The funds were disbursed and circulated from headquarters at the Ministry of Foreign Affairs, and he referenced the said memo which provided for payments with respect to their rehabilitation work to be approved by the ministry before payment is made to the contractor for each phase of the work. He suggested that the second accused was manifestly and routinely placed under a duty to comply with instructions without delay. His goal was ceremonial in nature, but for the erstwhile DG's memo dated 6th of December 2016, he argued that the second accused would not have signed the contract by reason of the fact that as a political head, he was not a member of the procurement committee. The emphasis on the phrase, quote unquote, without delay, suggests that the second accused was not allowed to do anything contrary to or outside the provisions of the said memo. The second accused, he argued, acted in good faith, and the prosecution has not shown evidence to prove the case. Counsel further argued that the second accused has no premeditation to commit the offences charged on counts 1, 2, 12, and 45 of the indictment. With respect to count 1, Mr. Samura Kamara, for the second accused, argued that the prosecution has not adduced evidence to prove that the second accused was in charge of managing the funds for the renovation of the Chancery building, disbursement of funds, or a member of the procurement committee or unit of the Ministry of Foreign Affairs. He went further to say that the procurement was done even before the second accused was appointed. With respect to count 2, Mr. Kamara relied upon the submissions made with respect to count 1. And with respect to count 12, he argued that no evidence was adduced that the second accused signed a contract or had improperly conferred an advantage on the sixth accused, Jules Sanders. With respect to count 45, the charges the offence of conspiracy, he submitted that the prosecution has not shown evidence of an agreement between the second accused and the sixth accused, and significantly, the second accused did not participate in any procurement process. Counsel further argued that the evidence of the witnesses contained serious inconsistencies. I'll deal with the prosecution's response. Mr. K.S. Conte for the prosecution responded by stating that on Friday, the 4th day of January 2023, counsel served a no-case submission on the prosecution for on behalf of the second accused, which the second accused was charged with the following offences: count 1, failure to comply with applicable procedures and guidelines relating to procurement; count 2, failure to comply with applicable procedures and guidelines relating to the tendering of contracts; abuse of office contrary to section 42(1), and conspiracy to commit a corruption offence contrary to section 128 of the Anti-Corruption Act as amended. Counsel further argued that the second accused, Mr. Kali Summa, appears to have miscomprehended the nature of a no-case submission. More importantly, he said there seems to be considerable confusion with regard to the law to be applied with respect to the offences as charged. And in that respect, with respect to the charge under section 48(2)(b) of the Anti-Corruption Act, Mr. Conte argued that contrary to the submission of defense counsel in the first paragraph on page 8 of its no-case submission, that the prosecution failed to adduce evidence of probative value. He said that Mr. Kamara failed to take into consideration Exhibit B1 to 52, which is the interview statement of the second accused in his answer to question 8 at page 11 through to page 12, where in answer to questions by the ACC, second accused has said the following: that it is not my duty as ambassador to do due diligence as provided in paragraph number 1 in the memo dated the 6th of December 2016. My duty is to sign the approved standard contract, and it is for the head of Chancery principal advisor to the ambassador to do the due diligence. He argued that failure to comply must be a willful omission. According to the natural meaning of the language used, negligence is sufficient. It is submitted, he said, that negligence in this context is failing to exercise such care or prudence that a reasonably diligent person in the second accuser's position would have exercised. It is submitted, therefore, that the second accused had a legal duty or responsibility to ensure compliance and exercise reasonable care in the handling of government funds. In inserting the alternatives willfully or negligently, said section 42, section 48 2b, the legislation intended that negligence would suffice in some circumstances. He relied upon the suggestion that the second accused deliberately ignored instructions stipulated in the memo dated 6th of December, which were tendered as Exhibit AQ 1 to 4, by failing to confirm with the head of Chancery whether the precondition that the contractor, Fairfield Construction Associates Limited, provide one, a valid business license or business registration certificate, a valid tax clearance, and a record of audited accounts for the past 2 years. According to the second accused, in his answer to question 9 of his interview at page 15 of Exhibit B1 to 52, he stated that it is not a precondition for him to see or cite the document referred to under the question before signing the contract agreement. And quote unquote, he said, my duty, as stated earlier, was to sign the approved contract. It is the submission of the prosecution, he argued, that it is but prudent for the second accused to have exercised due diligence before signing the said construction contract, which is exhibited as Exhibit U1 to 26. I deal with the offense under Section 48(b). Counsel for the prosecution submitted that, contrary to the defense counsel's arguments, in the second paragraph of page 15 of his notice submission, he submits that the cabinet paper, Exhibit AD 1 to 2, does not reflect when cabinet approved the contract. Rather, on page 2 of Exhibit AD 1 to 2, under the caption Cabinet Decision, it gives the following: that the Cabinet agreed that the Minister of Foreign Affairs and International Cooperation should hold consultations with the Minister of Finance and Economic Development on the funds required for the construction rehabilitation work. It submitted that the procurement was still in process by April 2016 at the time of the memo Exhibit 81 to 2 was sent, and that discussions were still ongoing with regards to the nature, format, and the contract type when the second accused assumed duty in September 2016 as ambassador and permanent representative of Sierra Leone to the UN in New York. Abuse of office, contrary to Section 42(1). With respect to this offense, the prosecution submits that in further proof of the offenses alleged under this section, it has shown that the third accused was acting in the course of his employment as a public officer when he facilitated payment to the contractor through its president, the sixth accused, Jones Sanders Davis, thereby improperly conferring an advantage on him. And deal with conspiracy to commit a corruption offense, contrary to Section 138 of the ACC Act as amended. With respect to this count, the prosecution submits that in this matter the prosecution has laid enough evidence to show that the willful act of the second accused not only caused but also deprived the government of Sierra Leone of public funds. The prosecution referred to the statement of the second accused under caution of Exhibit B1 to 52. And in that interview statement, which is part of the prosecution case, they argued that certain issues are raised that require explanations from the second accused. He argued that it would therefore be premature to decisively determine at this juncture that the essential elements for the offense of failing to comply with applicable procedures and guidelines relating to the procurement or failing to comply with applicable guidelines relating to the tendering of contracts, abuse of office, conspiracy to commit a corruption offense have not been proved, when it is clear from the second accused's own statement that he was the ambassador and permanent representative at the permanent mission of the Republic of Sierra Leone to the UN between 2016 June and 2018 July. That it was during his tenure he signed the construction contract, which is exhibited as Exhibit U1 to 26 for and on behalf of the government of Sierra Leone, and that he signed the construction contract without confirming that the precondition as provided for in bullet 1 on page 2 of the memo, Exhibit AQ 1 to 4, had been complied with. And with respect to that bullet point 1, it reads, quote unquote, request the contractor, Fairfield Construction Associates, to provide 1, a valid business license, business registration certificate, a valid tax clearance, and record of audited accounts for the past 2 years. Counsel argued that evidence abounds that the second accused, who is act and omission, failed to comply with procedures and guidelines relating to procurement by signing the construction contract, knowing that necessary requisites as detailed in Exhibit AQ 1 to 4, page 2, at bullet point 1 for signing the said contract have not been complied with. Evidence abounds to say that the second accused, who is acting on mission, committed abuse of office by improperly conferring an advantage on the sixth accused, June Sanders Davis, by signing the construction contract Exhibit U1 to 26, knowing fully well that the necessary prerequisites as detailed in Exhibit AQ1 to 4 at bullet point 1 for signing the said construction contract have not been complied with. It further argued that evidence abounds the second accused, who is act and omission, conspired with the sixth accused to commit a corruption offense by signing the construction contract, knowing fully well that the necessary prerequisites are detailed in Exhibit AQ1 to 4, page 2, at bullet point 1 for the signing of the said construction contract have not been complied with. The second accused in his interview with the ACC, marked as Exhibit B1 to 52, asserted at page 11 of the said exhibit in response to question 8 that it was not his duty as ambassador to do due diligence, as provided for in paragraph number 1 in his memo dated 6th of December 2016, and that his duty was only to sign the approved contract on behalf of the government. In his interviews with the Anti-Corruption Commission, marked as Exhibit B1 to 52, at page 40 and question 33, when asked if he knew of the precondition to signing the contract, the second accused is said to reply that it was a precondition for the contract between Fairfield Construction Associates for the head of Chancery to comply with before signing the contract agreement. The prosecution submitted that the second accused, who was the ambassador and permanent representative to the permanent mission of Sierra Leone to the UN between June 2016 and July 2018, failed to verify a very important precondition detailed in Exhibit AQ 1 to 4 before signing the construction contract. A fact that the defense, he argues, does not challenge. It is the prosecution's submissions that it is the failure as ambassador to exercise due diligence in the performance of his responsibility to verify a very important precondition detailed in Exhibit AQ 1 to 4 before signing the said construction contract is cogent and compelling evidence of failure to comply with applicable procedures and guidelines relating to procurement, and tender of contract, and abuse of office and conspiracy. Counsel argued that this was not a shifting of the legal burden to the second accused, but a factual inference of common sense that in the absence of evidence of a satisfactory explanation, this court can go from the evidence that that is indeed the case. Thus, if the prosecution, as in this case, proves that the second accused failed to exercise due diligence before signing the construction contract, it may be said that the second accused has the evidential burden to raise or show evidence of an explanation negating the inference of failing to comply with applicable procedures and guidelines relating to the procurement, failure to comply with applicable procedures relating to the tendering of contracts, abuse of office, and conspiracy to commit a corruption offense. Otherwise, it stated this court is safe to draw the inference of failing to comply with the applicable procedures and guidelines relating to procurement, the tendering of contract, abuse of office, and conspiracy to commit a corruption offense. He argued that the absence of a reasonable explanation by the second accused to charges within the indictment does present not only a prima facie case against him, but also abuses strong evidence of the charges as alleged. It further stated that in fact evidence abound that the second accused failed to verify a very important condition detailed in Exhibit AQ 1 to 4 before signing the contract, and in the absence of which the construction contract ought not to have been signed. Prosecution submits that on the whole it has established a prima facie case against the second accused, and it is probable that the second accused will be put to his defense. I'll deal with the conclusions in this case submission. I've carefully considered the submissions of both counsel in this matter, and as part of the consideration of the no-case submission and the response, I've also considered Exhibit AQ4 dated 6th of December 2016 in detail. The management of funds or portions of funds due and owing to them, which it is averred would have triggered investigations into whether procedures and or guidelines were followed in withholding such funds. In fact, Fairfield Construction, under the Chancery Building Common Tract, acknowledged as late as 21st of April 2021, not long before the trial of this matter, to no less a person than PW18 Ambassador Dr. Ali Kaba himself, in Exhibit A 1 to 2, to have received well over $4 million United States dollars out of the contract sum of $5,295,555 United States dollars. The said exhibit stated that the invoice sum as $4,669,549.45 US dollars, following a verified audit, and that the balance owing to Fairfield Construction as of 21st of April 2021 was only $626,005 United States dollars. Exhibit A 1 to 2 above is a letter from Fairfield Construction signed and endorsed by Jules Sanders Davis as president. It was argued that the case is based on the fact that the current prosecution is founded on an existing contract dated the 9th of December 2016, which was lawfully executed between the government of Sierra Leone, represented by the then Permanent Mission to the United Nations in New York, and Fairfield Associates Construction, represented by Mr. Jules Sanders Davis, the president, and managing member. With respect to this contract with the Exhibit U, he argued that it is within the existing contract that the third accused operated as financial attaché. The contract, which was exhibited as Exhibit U-126, specifies in Article 16 how changes can be made to the basic character, design, or scope of the project. Apart from the fact that the third accused never himself tendered or awarded any contract to Fairfield Construction, the said existing contract makes provision for events of default in the agreement and for termination or suspension by either party at Article 10. Neither the State of Sierra Leone nor the prosecution invoked the above clause in pursuance of the purported non-performance or default in its performance as alleged against the third accused. It makes specific emphasis on the fact that the contract itself provides that the agreement shall be governed by the State of New York as to the interpretation and performance of the said contract, and subject only to the jurisdiction of the United States Courts of New York. He relied on the environment of the prosecution as well as his case consistently failed to state and produce to the court the applicable guidelines that they rely upon. In fact, the fact that both PW8, Mr. Richard Williams, the Accountant General, and PW6, Mr. Septimus Johnson, who was the Principal Accountant and Minister of Foreign Affairs, explained that Sierra Leone Chancery Department in New York followed correct or relevant procedures in matters pertaining to the building project by seeking information and approval for every segment of the project and reporting on the progress of work as well. And PW6 explained the procedure involved in the request for funds from the Chancery to capital. The third accused was that once the approved sum is before the mission, the head of Chancery and administrative head of the mission takes full charge and controls his use and disbursement as the vote controller of the mission. And it further submitted that at all material times they served in the New York Foreign Mission, there was no official procurement unit set up there, and the mission only operated an ad hoc procurement unit. The third accused also states that he worked within the full mandate and limit of his job as financial attaché, as set out in the procedures above, as well as the letter from Ambassador Mrs. Florence Bangali, deceased was PW12. And he went further to say that because they had no official procurement unit, they relied on information from the Ministry of Foreign Affairs and approval from headquarters. The third accused further explained that in similar vein, it was at a Chancellor meeting held in New York that they agreed for the fifth and sixth floors to be added to the existing structure, and that this was communicated by the head of Chancery, the first accused, to the Ministry of Foreign Affairs, and approval was granted by the same ministry, which was exhibited at page 25 of Exhibit C-166. He argued that the base progress reports prepared by PW14 Mr. Alan George as Councillor and submitted to the Director General of the Foreign Affairs Ministry on behalf of the first accused were consistent with the fact that the first accused, supported by the third and the fifth accused persons at all material times, kept the Ministry of Foreign Affairs fully informed about the nation's activities, programs, and projects in New York. There were meetings held, and in those meetings organized and or masterminded by PW18 Dr. Ali Kabar and the self-appointed monitor or overseer of the Chancery Building Project PW17 Dr. Imran Khan, in place of the first accused, which meetings were attended by Johnson Davis for and on behalf of Fairfield Construction. The following were recorded in various minutes of meetings held on the 22nd of May 2020 and 1st of June 2020. And since those meetings were held all about June 2020, the evidence available to the court is that the necessary outstanding forms required for Fairfield to complete the Chancery Building in New York so that it can be open for official use were not made available to the company. He refers to the two technical reports of the Chancery Building project submitted by PW2 Mr. Paul Okari in October 2019 and with AK146, the second technical report in August 2021, and further extracts of the technical reports exhibit AK146 and AK13, which dealt with the percentage of works completed from the main building facade to the fifth and sixth floors of the Chancery Building, totaling 70%. He concluded that none of the sums of money listed out in the count charges under this rubric could be attributed to willful or negligent failure on his part and of the first accused to follow applicable procedures and guidelines known to them. All monies disbursed to Fairfield in the reconstruction contract were done in accordance with that contract, and the said company fully acknowledged receipt of the same and expended the money received in the manner specified. He argued that there was no record of impropriety or evidence of impropriety by any of the witnesses on behalf of the prosecution. He went further to say that no witnesses came forward to state the applicable procedures and guidelines referred to in the indictment, not to talk about how the third and the first accused willfully breached or failed to comply with them, if any, and counts involving to which they were needed to involve should be dismissed against himself and the first accused. Argument was 5, 7, 10, 18, 20, 22, 24, and 27, which deals with misappropriation of public funds. With respect to this count, prosecution made the third accused by himself and in some cases working together with the first accused, Mr. Nalo, misappropriated public funds. He relied on the dictum of Lord Justice Barmack, definition of misappropriation in the unimportant case of the state versus Common and Marx, which he says has resonated with the court. And Justice I.S. Finn J.A. adopted the same in the unimportant ACC case of the state versus Aisha Johansson. He further submitted that the above counts are inappropriate in view of the evidence laid in court against him and that the analysis already provided in respect of the previous offenses of failure to comply with applicable procedures and guidelines. In light of the above, reference is made to Exhibit AN 1 to 2, in which the sum of $4,669,549.45 US was acknowledged by Mr. Jules and the President as received by Fairfield Construction Associates. In fact, he went further to say that Mr. Davis acknowledged in his acknowledgement letter of 21st of April that he was looking forward to working with Ambassador Ali Kabak as permanent representative and bringing the Champions project to a conclusion which all parties involved can be proud of. Mr. Jules and Davis witness statement tenders Exhibit F 126 is replete with admissions by him of receiving the monies meant for the Champions project for and on behalf of his company, Fairfield. Counts 11 and 25 charges offenses of conspiracy, and the third accused argues that the offense of willfully failing to comply with applicable procedures and guidelines relating to the management of funds or the tenure of contract should fail, because the prosecution did not produce to the court any such applicable guidelines. And no evidence was alleged that indicated or suggested that the third accused was in any conspiracy with the first accused or any other person unknown. Count 13 deals with abuse of office, contrary to section 42(1). And Mr. Fofana, for the third accused, submitted that the third accused will adopt the arguments and submissions in respect of the previous counsel and deny the particulars set out in this charge. He relied upon David Montes's witness statement tendered by the prosecution Exhibit AX 1 to 13. At pages 5 to 10 of the said statement, Mr. Montesi states that due to the COVID-19 pandemic, which added to the company's overheads and rising costs of material, Fairfield was intent on upholding the total sum of $3,086,000 US for the change orders in respect of the 5th and 6th floors, but they were met with heavy resistance from the Sierra Leone Embassy team in New York. When the costs and expenses were reviewed and negotiated, the change orders costed only a total sum of $1,800,000, which was consequently paid out by Jules and Davis to Mr. Montesi's Empire Gold New York company. He argued that count 43 should therefore be dismissed. I agree with the reply by the prosecution. In response, Mr. Content of the prosecution submitted that the defense counsel served a no-case submission on them on behalf of their client, dealing with 9 counts relating to the management of funds, 8 counts of disoccupation, and 1 count of abuse of office. He repeated the point that there had been miscomprehension of the legal principles involved and relied on the case of court and the state versus Lucille Bond and 3 others, and Shepherd Stevens and another versus the Commission of Police 1960. With respect to failure to comply with applicable procedures and guidelines, relating to the management of funds submitted, and contrary to the submission of the Defense Counsel on paragraph 14 on page 6, the prosecution has not failed to state and produce to the court the applicable procedures and guidelines it relied upon. Instead, failure to comply is the willful commission, and according to the natural meaning of the language used, negligence is sufficient. On the submissions themselves, he submitted, and the third accused did prepare and make payments to the sixth accused. He deliberately ignored the provision that every acquisition must first be approved by an architect. According to him, because the contract for the derivation of the Chancellor building was to be signed by the President of Fairfield Construction, even the financial attaché started honoring the request approved by the head of Chancery in favor of the contractor. With respect to the offense of misappropriation of public funds, Mr. Contest submitted that the mentally and actively of the crime of misappropriation are built on fraud, not on dishonesty or negligence or willful failure to act as they should, and said that the elements of the offense are created under section 36(2) of the Anti-Corruption Act 2008 as amended, and these elements were listed from A to E. With respect to the offense of abuse of office contrary to section 42, he further submitted that proof of the offenses alleged showed that the third accused was acting in the course of his employment, and in the course of that employment, he improperly conferred an advantage on the sixth accused through circumstances. With respect to conspiracy to commit a corruption offense contrary to section 128, he argued that there led enough evidence to show that a willful act of the third accused not only caused but also deprived the state of public funds. And he referenced the statement of the third accused, which was exhibited as Exhibit C1 to 66. In that intimate statement, which he said is part of the prosecution's case, there are issues that are raised that require explanations of the third accused, and he respectfully submitted that it would be premature to determine the case at this evidence without hearing from the third accused. He argued that the evidence suggests that the third accused, through his acts and omissions, failed to comply with the procedures and guidelines stipulated within the construction contract, when he consistently prepared and issued payment vouchers and check payment requisitions he received, which were not approved by any architect, thereby causing the state to lose public funds. The third accused, he argued, through his acts and omissions, willfully caused the misappropriation of public funds between December 2016 and 30th of September 2018, thereby causing the state to lose such public funds. And through his acts and omissions, he also committed an abuse of office. Further, he had conspired with the other persons unknown, as well as the first accused to commit a corruption offense by willfully failing to comply with applicable procedures and guidelines related to the disbursement of funds for request by the sixth accused. With respect to that, he relied upon Exhibit C1 to 66 and page 54 and question 78 of the third accused's interviews to the ACC. He went further to argue that with respect to Exhibit C1 to 66, there's an assertion of page 5 of the said exhibit by the third accused that his duties and responsibilities include to make payments to service providers such as electricity and water payment to staff. And page 12 to 17, he admitted to having made several payments to the contractor, the sixth accused. And Exhibit AN1 to 2 details the payments received by Fairfield and Further, in Exhibit A, G 1 to 7 and AI 1 to 7, the requisition order forms titled Application Certificate for Payment do not bear the name of the architect. And the requisitions also do not contain the signature of the said architect, whereas Exhibit AF 1 to 10 is not supported by any application and certificate of payment for. The third accused, AIBs, has not challenged the evidence that he prepared and made payments in Exhibits AF 1 to 10, AG 1 to 8, and AI 1 to 7. He went further to say that the exhibit mentioned above reflects and confirms that the third accused was said in the statement Exhibit C1 to 66 at pages 12 to 16 that the initial payments commencing from the deposit in 2016 of $250,000 to the ninth payment made on August 13, 2018 of $187,000 was made by him. The prosecution submits that the third accused being the finance attaché between March 2011 and September 30, 2018 prepared and made the said payments, a fact that the defense does not challenge. It is the prosecution's submission further that its failure as finance attaché to exercise due diligence in the performance of the possibility to verify all supporting documents received for payment is a cogent and compelling evidence of failure to comply with the applicable procedures and guidelines related to the management of funds, misappropriation of public funds, abuse of office, and consequently commit a corruption offense. Counsel further referenced the state of Mustafa Kamara, in which Katuzi J cited cause of evidence with approval as follows: that the evidence against the man may be strengthened by his failure to give an explanation of conduct proved or alleged against him, or the inadequacy of explanation which he gives. Prosecution further submitted the absence of a reasonable explanation by the third accused to charges within the indictment does present not only a prima facie case against him, but also strong evidence of the charges as alleged. And counsel finally submitted that the no case submission is ill-conceived and should be dismissed. I'll go to the conclusions of the no case submissions. I've considered very carefully the submissions made, particularly with respect to the alleged inconsistencies in the evidence introduced and in response from the third accused. Having considered the totality of the evidence adduced by the prosecution in this case against the first accused, I cannot at this stage of the trial come to the conclusion that in accordance with the Gabriel test, that there is no evidence that the crime alleged has been committed by the first accused. Having considered the totality of that evidence further, I again cannot at this stage conclude that the prosecution's evidence taken as highest is such that the jury, or in this case, where it is alone as the trier of facts and properly directing itself as to the law and facts, could not properly convict upon it. I have, however, concluded that having reviewed the prosecution's case and the submissions made, the prosecution's evidence is such that its strength or weakness depends on the view to be taken on witnesses' reliability or other matters which are generally speaking within the province of the jury, and where on one possible view of the facts there is evidence upon which I could probably come to the conclusion that the first accused is guilty of one or all of the offences charged and duty bound to allow the case to proceed to the trial of the evidence, thereby requiring the first accused to put a defense to the charges he faces. I consider that in accordance with the decision of the Court of Appeal in Gordon, taking the prosecution's case as its highest, and having properly directed myself, I could be entitled on one view of the evidence to reach an adverse inference and not entitled to stop the case at this stage, but to require that the third accused be put to his election as a put to defense in answer to the charges. In the circumstances, the notice submission by the third accused is overruled and is required to be put to his election in a bid to put his defense to the charges he pleaded. The fourth accused. The defense submitted a case notice submission on behalf of the fourth accused on the 3rd of January 2023. I've carefully considered the contents of the entirety of the submissions and that of the prosecution in response. The fourth accused is charged with 2 counts of amended 48-count indictment, that is count 47 and 48. Count 47 under section 40, subsection 3 of the Anti-Corruption Act 2008 as amended by the ACC Act of 2019, and the fourth accused is also charged with misappropriation contrary to section 36(1) of the 2008 Act as amended by the 2019 Act. The submission relied upon by the Anti-Corruption Commission Act as amended by Council and the Criminal Procedural Act, and also Council further relied on the Evidence Act, which is unknown, and the Public Procurement Act of 2016 as amended. Further, Defense Counsel relied upon the following rulings in the DPP, Top V Commissioner of Police, R.B. Bob Jones, Gareth, and Lord Parker's practice direction on notice submission 1962 and local authority on misappropriation. They also relied upon a number of exhibits which were tendered by the prosecution in their case, which can be set out as follows. Exhibit D1 to 58, the interview statement of the fourth accused. Exhibit U, the construction contract, the derivation of the Chancery Building in New York, dated the 9th of December 2016. Exhibit AC 1 to 5, the cabinet paper dated the 18th of April 2016. Exhibit AB 1 to 2, the main paper dated the 18th of April 2016. Exhibit AQ 1 to 4, the Director General of Foreign Affairs letter dated 6th of December 2016. And exhibit AS 1 to 4, which is the invitation for bids to renovate the Chancery Building dated 21st of September 2015. With respect to count 47, he is charged with deceiving the principal, contrary to section 43, subsection 3 of the Anti-Corruption Act 2008 as amended in 2019. And with respect to count 48, he is charged with misappropriation of public funds, contrary to section 36(1) of the 2008 Act as amended in 2019. The primary submission by counsel is that the indictment that charges the fourth accused describes him as being a former Minister of Foreign Affairs and International Cooperation, and he argues that the fourth accused at the time the alleged offense was committed was not a former minister but a substantive minister. And clearly, he argues there's a discrepancy between the description of the said accused and actions for which he is purportedly charged. And he addressed the court on this issue in his submission. Counsel further submitted that it's the duty of the prosecution to prove the guilt of the fourth accused beyond reasonable doubt, but the prosecution has failed to attain this sacred duty in instant case. The fourth accused should be acquitted and discharged by this court on both counts by reason of the following matters. 1. With respect to count 47, which is the charge of deceiving the principal contrary to section 40, subsection 3, it is submitted that the prosecution should only succeed if they are able to prove beyond reasonable doubt that the fourth accused knowingly and intentionally submitted to the cabinet a cabinet paper document that was misleading and untrue, and with intent to mislead, presumably, the government of Sierra Leone. No evidence whatsoever was led to that effect. Council referred the court to Exhibit G1 to 58, which was a statement obtained by the Anti-Corruption Commission from the fourth accused over several days. In their first statement, the fourth accused categorically refuted the allegation of misleading the principal. Counsel rhetorically asked the question, what is the evidence before the court? And with respect to that question, they rely upon Exhibit D1 to 58, in which the fourth accused totally denied the accusation of misleading the government of Sierra Leone. Counsel also referred the court to Exhibit AC 1 to 5, which is the cabinet paper dated the 18th of April 2016, and Exhibit AD 1 to 2, which is the main paper dated the 18th of April 2016, neither of which they argued was authored by the fourth accused. This, they argued, was confirmed by the testimony of PwC Mrs. Sonia Karim, who testified in court that Exhibit AC 1 to 5, the cabinet paper dated 18th of April 2016, was prepared by the Cabinet Secretariat in conjunction with the Directorate of Foreign Affairs on International Cooperation without any participation by the fourth accused. Following from that, Mr. John Somalia PW4, the Cabinet Secretary and Head of the Civil Service, testified that the fourth accused was not present in Cabinet and did not present or participate when the matter of Exhibit AC 1 to 5 was discussed. On technical glitch, our failure. That it was during his tenure says the notice submission by the first. The following: that with respect to cabinet document that was misleading and untrue and with intent to mislead, presumably the government presiding. No evidence whatsoever was laid to that effect. The fact court to be deep by the cabinet secretariat in conjunction with the Directorate of Foreign Affairs of the National Corporation without the participation of the fourth accused. Following from that, Mr. John Samura, the cabinet secretary and head of the civil service, testified that the fourth accused was not present in cabinet and did not present or participate when the matter of exhibit AC 1 to 5 was discussed. Furthermore, the testimony of Mrs. Karija Tubasi, exhibit 12, is instructive. She stated that the fourth accused was not involved in the preparation of the cabinet paper exhibit AC 1 to 5, nor did he sign it or concerned with the implementation of projects. She emphatically told the court that the implementation of projects approved by cabinet was the business of civil servants and that the minister can only be informed of progress. Council further relied on the evidence of PW18 Ali Kabak and confirmed this narrative in his testimony to the court, and stated that the minister is generally not involved in financial matters or the implementation of projects at the Ministry of Foreign Affairs, where he once served as minister. The prosecution, he argues, have therefore not provided any sufficient evidence beyond a reasonable doubt that the fourth accused deliberately, knowingly, and unintentionally misled his principal, to which supposedly the government of Sierra Leone. On the contrary, it argued that there is uncontroverted evidence that by the time the fourth accused left office in 2017, the sum of $2 million United States dollars was already ring-fenced for the New York Chancery building project. And he argued that there is confirmation of this from Bokali Noah, who was PW1, who testified that the investigation of the matter by the Anti-Corruption Commission revealed that the sum of $2 million had indeed already been deposited into the Consolidated Revenue Fund at the Bank of Sierra Leone. They further argued that on the totality of the evidence, therefore, the prosecution failed in its duty in that they produced no evidence to prove beyond all reasonable doubt that the fourth accused knowingly and intentionally misled its principals, presumably the government of Sierra Leone, in this regard. Accordingly, they submitted that the court must by law acquit and discharge the fourth accused for want of any evidence to prove the charge is made. Counsel further argued that the prosecution must prove that the fourth accused knew the effect of his conduct as being misleading to the principal, presumably the government of Sierra Leone. In the instant case, the fourth accused neither prepared nor did he present the cabinet paper exhibit AC 1 to 5 to cabinet. Consequently, it could not have deceived or knowingly presented a misleading document to the principal. The resultant effect is that the prosecution had failed to prove the case against the fourth accused on count 47 of the indictment. Further, the defense counsel submitted that the interministerial committee is tasked with the implementation of the Cabinet's conclusion. This consisted of the Ministry of Foreign Affairs and International Cooperation, Ministry of Works, Housing and Infrastructure, Ministry of Finance and Economic Development, the Attorney General and the Minister of Justice, the National Public Procurement Authority, the Sierra Leone Permanent Mission to the United Nations, and the Office of the Chief of Staff, State House. He further argued that the fourth accused had no part whatsoever in all of this, other than having been nominally the Minister of Foreign Affairs and International Cooperation. Monies were transmitted without his knowledge, approval, or participation. He was neither copied in on any correspondence, nor did he take part in the proceedings or financial transactions whatsoever in relation to the New York Chancery project. And consequently, they reiterate the fact in their submission that there is no evidence or no sufficient evidence on which a successful prosecution and conviction of the fourth accused can be secured. With respect to count 14, the fourth accused was charged with misappropriation of public funds under the section 36(1). And counsel submitted that the fourth accused was in no way either by action or omission implicating the charge. The evidence presented does not prove the element for successful prosecution of the offense of misappropriation. Counsel further relied upon the proposition on the basis of the dictum in these principles laid down for successful prosecution in the cases of the State versus Aisha Johansson and Samura Kamara only reported, in which Phil J. described the elements of misappropriation. The land judge, they argued, went on to cite with approval at page 7 the dictum of the Honorable Justice N.C. Mark J.A. as it then was in the reported case of the State v. Comet and Matt, where he described misappropriation in the following words: it as involving the assumption of the rights of the owner, and in this case, a willful commission of acts which result in the owner losing funds belonging to it as amounting to misappropriation. Counsel argued it is clear, therefore, that the prosecution must prove that the defendant took the money alleged to have been appropriated dishonestly, and proof of such appropriation can be found in the actual taking as per the dictum of the Honorable Justice R.S. Phil J.A. In summary, counsel further submitted that the prosecution did not leave or tender evidence that even remotely suggests that the fourth accused, while serving as Minister of Foreign Affairs and National Cooperation, appropriated or took all or any part or parts of the funds allocated for the rehabilitation, construction of the Sierra Leone Chancery building in New York. He argued that as a matter of fact, there is documented evidence that confirms that Jules and Davis, the sixth accused, acknowledged the receipt of all payments made to Fairfield Construction LLC in respect of the referred project. Counsel further submitted that applying the said dictum, the prosecution did not leave or tender any evidence that even remotely suggests that the fourth accused, while serving as Minister of Foreign Affairs and International Cooperation, appropriated or took any of the funds allocated for the rehabilitation of the Sierra Leone Chancery building of the New York Chancery Commission. He relied upon the evidence of PW1 and concluded that there is no sufficient evidence to convict the fourth accused. On the issue of dishonesty, counsel submitted that the fundamental question to address is having regard to the totality of the evidence and bearing in mind the absence of any share of evidence that the fourth accused appropriated all or any part of the referred funds. Can the prosecution seriously and or successfully argue that the fourth accused committed any act of dishonesty? The case of Galvez was relied upon to substantiate this submission. Counsel further argued that evidence led by the prosecution up to the closing of its case establishes no nexus between the fourth accused and alleged offenses committed. and evidence is therefore insufficient. And additionally, so tense that it is mostly unlikely to secure a safe conviction in any circumstance, including a jury trial. The further submitted that the fourth accused has no case to answer and will end with a paraphrase of the law as stated at page 1430 of Blackstone's criminal practice of 2002, which reads that a notice submission must be considered if the prosecution's witnesses' evidence is too inherently weak and vague for any sensible person to rely on it. Counsel further went on to state that, in other words, the judge need not pretend to believe arrant nonsense. Thus, if the witnesses undermine their own testimony, as in this case, by conceding that they are uncertain about vital points material to prove the essential element of the prosecution's case, or if what they say is manifestly contrary to reason, the judge may be entitled to hold that no reasonable jury properly directed could rely on the witness's evidence, and therefore, in the absence of any other evidence, there is no case to answer. I agree with the response by the prosecution. The prosecution responded to the no case submission by the defense and relied upon the following matters. One, the indictment implies that former after fourth accused was not Minister of Foreign Affairs and International Cooperation as of the date of the indictment. Two, the prosecution onus to prove the case against the fourth accused beyond reasonable doubt could not be inquired into or asked for at this stage of the trial. Thirdly, reference is made to section 39(7)(a) of the Anti-Corruption Act of 2008 as amended, which provides as follows: that a cabinet minister shall be deemed to be an agent for both the cabinet and the government. It is submitted, therefore, that even if the indictment are not so clear, the said commission would have been in place. Section 40, subsection 3 of the Anti-Corruption Act of 2008 provides inter alia that an agent who, to the detriment of his principal, uses or gives to his principal a document that arose contains anything that is false or misleading in any material respect commits an offense. Counsel for the prosecution, Mr. Contest, submitted further that the phrase "in any material respect" in this provision and within the content of the fourth accused's statement to cabinet as set out on the cabinet paper, which is exhibited as Exhibit AC 1 to 5, must be the fact of verification and vetting which the accused submitted and which the fourth accused cannot now support by evidence. It further submitted that the phrase "in any material respect" in this position and within the context of the fourth accused's statement to cabinet in Exhibit AC 1 to 5 must mean the fact of verification and vetting which the fourth accused submitted and which he himself cannot now support by evidence. He submitted that the fourth accused knew at the time of submitting the cabinet paper that he did not have at his disposal any facts of vetting or verification, and that it is to be implied that even if there was no falsity, there was at least an entity to it that the cabinet was misled, resulting from the categorical statements in the document. It further submitted that the proper approach to notice submissions is that set out in the case of Gabriel and the case of Goddard 2012, England Wales Court of Appeal, Criminal 1756. Counsel further submitted that there is need to consider the evidence as a whole, as was illustrated in the case of Sheep 1988, Criminal Law Report 77, and the decision, he argued, did not depart from the two-legged tests in the 1 and 2 as set out in Gabriel. Closer to home, he further argued that the state versus Muslim born and three others after reference to the legal cases of Gabriel and Shepherd Stevens and another were clear on the point that the accused should be acquitted on a no case submission where there is just a mere scintilla of evidence. He went further to cite the following words, but here I am of the view that at the close of the prosecution's case, there is more than a scintilla of evidence pointing to the matters which the prosecution has proved, taken as its highest. It is evidence upon which a jury properly directed could convict. It is another matter which I have to decide at the end of the case, but not at this stage. I do not defend or deceive the principle contrary to Section 43 of the Anti-Corruption Act of 2012-2008 amendment. With respect to this offense, the prosecution submitted that it is established that the fourth accused was the Minister of Foreign Affairs in 2016, and that in his capacity as Minister, he presented the Cabinet for the consideration and conclusion of the Cabinet a Cabinet paper, which was exhibited at Exhibit 18-1-5, in which the following statement was made. The companies undertaking the construction, renovation, and liable and are subjected to rigorous vetting. Counsel further argues that one, the fourth accused must of necessity have submitted the said paper with the intent that the Cabinet will accept such proposals. And secondly, that as the Minister with such responsibility, the onus and the responsibility was on him, that at the end of the day, such statement was true and was being presented consciously. And third, by implication, the fourth accused was saying, even though, in not so many words, that the said companies, including Fairfield Construction, were to be relied upon by the Cabinet and the government. Prosecution further submitted, therefore, the fourth accused was submitting to Cabinet through the white paper that the company being recommended have been scrutinized in a thorough, logical, and scientific way, and that the same has been examined with extreme care, and as a question of fact, that what the fourth accused was suggesting was not the case for the following reasons, and the giving the following circumstances which are set out in the submissions. Counsel further argues that the statement of Cabinet was submitted on the 18th of April 2016, and the decision was taken on the 22nd of April 2016 by Cabinet. In that light, he argued that it is significant to note the content of the fourth accused's statement to the Anti-Corruption Commission. In that statement, at page 20, the fourth accused was asked what rigorous vetting had been done in respect of the said company, and the fourth accused replied that he could not tell. He stated clearly on the same page of his said statement that the Cabinet paper he submitted was based on information by the Interministerial Technical Committee, which had been ordered by Cabinet. Counsel for the prosecution disputes this version of events on the basis that the said committee came into existence or was ordered to be formed after the said Cabinet paper had been presented to Cabinet by the fourth accused on the 18th of April 2016. In that same interview, he argued the fourth accused could not tell who the members of the said committee were, but more interestingly, after several suggestions had been made to the fourth accused in the interview, he agreed that there may not have been any vetting at all of the company's reference in his Cabinet paper, thus establishing the Cabinet was misled. Reference was made to the following issues which suggest that at the time the Cabinet paper was being presented to the Cabinet, the Ministry of Foreign Affairs and International Cooperation was not in possession of relevant facts upon which the fourth accused could have based his judgment of proper scrutiny or vetting. By memorandum from the then Director General and Ambassador at large to the Minister Plenipotentiary and Head of Chancery dated 6th of December 2016, which is Exhibit AP 1 to 4, the Head of Chancery was inter alia being asked to ensure that the following details were to be supplied by the contractor Fairfield Construction Associates. 1. A business license. 2. A valid tax license. And 3rd, a record of audited accounts for the previous 2 years. This memorandum of the 6th of December 2016 was sent to have been as a result of a memorandum dated 30th of November 2016 from the then Solicitor General giving his opinion on the matter. However, 3 days subsequently, the Director General and Ambassador at large had sent this memorandum to the Minister Plenipotentiary and Head of Chancery that a contract between Fairfield Construction Associates LLC and the government of Sierra Leone was signed by the second accused. I deal with this information in public funds. With respect to this count, the prosecution placed reliance on the interpretation of the words willfully as enacted in section 36 of the Corruption Act as amended. The ingredients of the said offense have been declared in some cases like the state v. Lukule and the state v. Ajata as intentionally recklessly delivery, though some schools of thought have suggested cancelling the related meaning of deliberately or voluntarily should not be the yardstick. Counsel for the prosecution submitted that it was by the aforementioned act by the fourth accused the public body of the government of Sierra Leone was subsequently deprived when all the disbursements and payments made to and received by the contractor Fairfield Construction Associates during the period of 2016 and 2021. It was submitted as a question of fact that had there not been the said cabinet paper exhibit AC 1 to 5 with the said statement contained therein that was made by the fourth accused and signed, all the consequential circumstances resulting therefore may have been different. The issue which triggered the whole scenario from 2016 to 2021 was the cabinet paper of the 18th of April 2016. In conclusion, the prosecution counsel submitted that it has established a prima facie case against the fourth accused and it is proper that the fourth accused be put to his defense. The no case submission is ill-conceived, argued in this matter, and the case should not be stopped as there is overwhelming evidence against the fourth accused that need to be addressed. I'll deal with the conclusions on this no case submission. I've carefully considered the submissions made by counsel for the prosecution and defense. And in light of the submissions made, I have gone on to carefully consider Exhibit AC 1 to 5, which the prosecution alleges was the vehicle through which the offenses allegedly committed by the fourth accused were so committed. The third exhibit is a cabinet paper which makes the following points which I consider expedient to set out, albeit in summary form. Well, firstly, that the document is dated the 18th of April 2016 was a memorandum by the Minister of Foreign Affairs and International Cooperation. 2. The cabinet was invited to consider a number of recommendations which include the following matters again in summary form. 1. Approval of option 2, totaling $2,560,000 United States dollars at the cost of completing the rehabilitation of the Chancery Building in the New York Mission, subject to negotiations with Fairfield Construction Associates and the government of Sierra Leone to be represented by the Ministry of Foreign Affairs and International Cooperation. Second, authorization of the transfer of the sum of $2 million United States dollars by the Ministry of Finance to the Permanent Mission of Sierra Leone in New York, being grant funds provided in 2012 by the People's Republic of China and ring-fenced in the budget for the rehabilitation of the Chancery Building in New York. Third, authorization of the transfer of the sum of $500,000 United States dollars by the Ministry of Finance to the Permanent Mission in New York, being budgetary allocation for the said rehabilitation. 4. Authorize the Ministry of Foreign Affairs, Finance, and the Attorney General and Minister of Justice to monitor and supervise the rehabilitation works to the Chancery Building and residents in Ethiopia and to provide regular reports. 5th, no addition of a 4th floor and a construction period of 36 weeks, to name a few of the financial implications as provided for in the said memo by the then Minister of Foreign Affairs and International Cooperation, who is the 4th accused. 6. Consultations across government were carried out with the Ministry of Foreign Affairs, Ministry of Works, National Public Procurement Authority, amongst others, the Office of the Chief of Staff, and the Office of the Attorney General and Minister of Justice, amongst others, and that they were issued with concurrence of the acting Minister of Works, Housing and Infrastructure. 7. Evidence that proposed intervention is needed and will include an environment that companies undertaking the innovation construction are liable and were subjected to a rigorous vetting process. 8. Annexed to the document is a document from Fairfield Construction Associates in respect of the New York Mission dated the 4th of January 2016 and addressed to the 4th accused. This document refers to a meeting held on the 30th of December 2015 and was signed by the 6th accused. And 9. The document itself has the signature of the 4th accused, Dr. Samura Kamara, as Minister of Foreign Affairs and International Cooperation. Having considered the totality of the evidence adduced by the prosecution in this case against the 4th accused, I cannot at this stage of the trial come to the conclusion that in accordance with the Gabriel test, there is no evidence that the crime alleged has been committed by the 4th accused. Further, I cannot also at this stage conclude that the prosecution's evidence taken as its highest is such that the jury, or in this case, where I sit alone as a trial of facts and properly directing myself as to the law and the facts, could not properly convict on it. I have, however, concluded that having reviewed the prosecution's case and the submissions made, the prosecution's evidence is such that its claim for weakness depends on the view to be taken of the witness's reliability of all the matters which are generally speaking within the province of the jury, and where on one possible view of the facts, there is evidence upon which I could properly come to the conclusion that the 4th accused is guilty of one or all of the offences charged, and duty bound to allow the case to proceed on the evidence, thereby requiring the 4th accused to put a defense to the charges he faces. I consider that in accordance with the decision in Gordon 2012, England and Wales Criminal Court 1756, taking the prosecution's case as its highest, and having properly directed myself, I could be entitled on one view of the evidence to reach an adverse inference. In those circumstances, I am not entitled to stop the case at this point, but to require the fourth accused to put the defense in answer to the charges. In the circumstances, the notice submission by the fourth accused is overruled and is required to be put to his election in a bid to put his defense to the charges he faces. I'll deal with the fifth accused. The fifth accused submitted his notice submission on the 23rd day of January 2023 and is charged with 16 counts of offenses which can be summarized as follows. 1 count of conspiracy to commit a corrupt offense, 8 counts of failure to comply with applicable procedures and guidelines relating to contracts, contrary to Section 48(3)(b) of the 2008 Act as amended in 2019, and these were with respect to counts 26, 28, 30, 32, 34, 36, 38, and 40. And 7 counts of misappropriation of public funds, contrary to Section 36(1) of the Anti-Corruption Act No. 12 of 2008, as amended in 2019, as contained in count 29, 31, 33, 35, 37, 39, and 41. With respect to this notice submission, the fifth accused relies on both limbs of the Gabriel test. The submission and prosecution have not made out his case, and they are making a notice submission because the accused is under no obligation to respond to tenuous and vague allegations. The proper approach to the submission of notice to answer is very well built and established, and they rely on the test set out in Gabriel. Notice submission of the fifth accused is summarized as follows in respect to Section 48(2)(b) of the 2008 Act, count 26. The defense refers to the fact that this count alleges that the fifth accused being the financial attaché of Sierra Leone Permanent Mission to the United Nations in New York on days unknown between the 1st of January 2017 and the 30th day of November 2017 at the UN Mission in New York, negligently failed to comply with applicable procedures and guidelines relating to the management of funds with payment of the sum of $35,000 United States dollars to Johnson and Davis, President of Fairfield Construction. Council further relied upon the E1 to 51, which showed that in 2016 to some parts of 2018, the fifth accused person was a senior accountant in the Ministry of Health and Sanitation, and it was in August of 2018 they were posted to the permanent mission of Sierra Leone to the UN in New York. In fact, it was at the end of September 2018 that they took over the said position as financial attaché. It was submitted that the fifth accused was not even posted at the said mission at the first day of January 2017 and the 30th day of November 2017. Counsel for the argue that the fifth accused an alibi for fail to take a look at it. Paragraph 701A provides that the contractor and architect meet at the work site to review the contractor's performance and completion of certain items of work, and that the requisition for question 35 and question 65, sorry, the only question was asked, when did you read the said portion of Article 7 of the contract? Answer on the 23rd of July 2021. The Prosecution contends the field accused assumed duty at the end of September 2018, and this was verified in response to the E1 to 58, in response to question 8 at page 5 of the interview dated the 21st of June 2021. But they contend that he was already making payments without having read or seen the construction contract in E1 to 26, or in fact, familiarized himself and with several payments to the contractor of the construction contract. Counsel further argued that not only did the fifth accused prepare and make payments to the sixth accused, he deliberately ignored the provisions of Article 7 of the construction contract that provided that every position must first be approved by an architect. According to him, because the head of chancery, who is the board controller, explained to him the contract terms and specifically the payment terms, and there was an ongoing payment towards the project of the library, so it was the head of chancery who did it all. In Exhibit E1 to 58, the answer to question 68 and page 27, the field accused answer as stated above. Counsel contested is concluded for the field accused to have exercised due diligence by familiarizing himself with the review 1 to 26, which is the construction contract, before preparing and making payment to the sixth accused without validating the merits of the acquisition submitted. PW 18 in the statement to the ACC, for instance, page 8 to 9, makes the same observation of the failure to follow applicable procedures, particularly with regard to change order 3, which made provision for the payment of 1,950,000 euros to Fairfield Construction, represented by the sixth accused, for construction of the fifth and sixth floors. There was no cabinet approval for this substantial additional work, which was procured without following applicable procedures and guidelines. Counsel for the state also makes reference to the amount of 202,000 US dollars, 682,000 US dollars, and was allegedly paid to Fairfield Construction, represented by the sixth accused, without any authorization and which had no documentation through which it could be verified. The field accused by his own submission will question whether the acquisition payments he made were supported with documents certified by the architect in an interview with the Anti-Corruption Commission investigators in Exhibit E1 to 58, commencing at page 40 to page 43, question 71 to question 76, affirms that the various acquisitions were not supported with certified documents by an architect, and he affirms this in his reply to question 74. Failure to comply Prosecution added must be a willful omission. According to the natural meaning of language used, negligence is also sufficient. It is submitted by counsel that negligence in this context is failing to exercise such care or prudence that a reasonably diligent person in the fit accused position would have exercised. Prosecution submitted that the fit accused had the legal duty to ensure compliance and exercise reasonable care, and certainly the alternative to willful negligently in section 48 to be the legislature seems to have intended that negligence will suffice. Counsel for the prosecution further submitted that not only did the field appeal prepare payment vouchers and make payments, he also deliberately ignored his responsibility to exercise due diligence when making payments. He further argued that there is no merit or substance to the submission on his behalf that he should be discharged. The procedure was blatantly disregarded and all the elements that constitute the offense have been proved. With respect to interpretation, counsel will state sought to draw the distinction between the requirement for dishonesty in section 37 and absence of it in section 36, to which I already alluded. He went further to say that not only did the fifth accused prepare and make payments to the sixth accused, he deliberately ignored the provision of the position being approved by an architect. And in his witness statement to the ACC, the fifth accused is said to have claimed that the head of Chancery, who is the vote controller, explained to him that the contract terms and specifically the payment start, and there was ongoing payment towards the project before his arrival. He went further to submit that by the Convention Act to the fifth accused that the public body the government of Sierra Leone was subsequently deprived when all disbursements and payments were made and received by the contractor Fairfield Construction. For argued that the question of fact, the fifth accused from the rise himself to exhibit EU 1 to 26, and had he done so, the construction contract between the permanent mission of the Republic of Sierra Leone to the United Nations and Fairfield Construction before preparing and making payments to the sixth accused, or on the consequential circumstances resulting therefrom may have been different. With respect to defendant conspiracy, counsel submitted that no doubt whatsoever that the accused persons committed these offences in their individual capacities and as well as in the conspiratorial capacity by failing to comply with the applicable procedures and guidelines. He argued that the fifth accused argument is contained in the last paragraph of the submission that with the totality of the evidence before the court, no evidence was laid against the fifth accused, leading to the fact that he conspired with any of the accused persons. He argued that not even the first accused, whose counsel in court at a stage even grew annoyed on the basis that the fifth accused was trying to shift the burden, can't be sustained for reasons already canvassed in the prosecution's response. Evidence has been led of willful acts, and they submit that on the whole, a verification case has been established against the fifth accused, and the fifth accused should be put in defense. The prosecution submits that no case of admission is still conceived, and the case must proceed to trial. Conclusion from the local submission. I have carefully considered the submission of the counsel of the fifth accused and the prosecution. I come to the conclusion that the prosecution has laid a verification case against the fifth accused. There are aspects of the evidence adduced against him that require further consideration. Having considered the totality of the evidence adduced by the prosecution in this case against him, I can't at this stage of the trial come to the conclusion that according to the Gabriel test, there is no evidence that the crime alleged was committed by the fifth accused. Further, I cannot also at this stage of the trial conclude that the prosecution's evidence taken as its highest is such that the jury, or in this case, where I sit alone as the trial of fact and law and properly directed myself as to the law and the facts, would not properly convict the police. I however concluded that having reviewed the prosecution's case and the submissions made, the prosecution's evidence is such that the strength or weakness depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury, or in this case, I have to try to fact. And where on one possible view of the fact, there's evidence upon which I can properly come to the conclusion that Faith Hill is guilty of one or all of the offenses charged and duty bound to allow the case to proceed to the trial of the evidence, thereby requiring the Faith accused to put a defense to the charges he faced. I consider that in accordance with the decision in Gordon 2012, taking the prosecution's case as its highest, and having properly directed myself where I could be entitled on the one hand, the evidence to which an adverse inference, I'm not entitled to stop the case at this point, but to require the Faith accused to put a defense in answer to the charges. In the circumstances, the notice submission by the Faith accused is overruled and is required to be put to his election in the bid to put his defenses to the charges he faces. Until the sixth accused. The sixth accused has not filed any notice submission and has not participated in this trial, neither has he subjected himself to the jurisdiction of the court. I did give an order that the trial proceed against him in his absence. The prosecution has led sufficient evidence to warrant that the sixth accused could even at this stage file a defense in answer to this charge. If he so pleases, I consider the prosecution's case to be sufficient to warrant him to put a defense on the charges he faces. The notice of submissions failed in the entirety, and all of the persons save for sixth accused will now be put to their election. This is the will of the court. Right. Thank you for all of you. The law, as you are aware, requires me to put the same person to the election. But before I do that, I'm going to give an opportunity to all counsel, if not already done, to confer with the client as to which way they intend the election to go. So I'm going to write it for 10 minutes to give you an opportunity to do that. And when I return, the accused person will go to the election. Yes.
Yeah. First of all, we want to thank you for the time. With that said, in view of the fact that the ruling is just coming, we respectfully plead with you because time to confer with our respective clients. And considering that there were other issues that I wanted to deal with which were pending on the outcome of the notice submission, matters relating to whether the prosecution will still want to call any witness depending on, because we have not asked them on whether they want to still proceed with that. Matters of the local visit, if any. But over and above that, we really believe that at this stage we will need time to take specific instructions and not just 10 minutes. Because, in my case, I have 30 counts against the first accused and the 20 or more against the third. Both myself and Mr. Gibao's case. So, 10 minutes, respectfully, will not be sufficient. And over and above that, we also believe that on the basis of equality of arms, we need the same defense conference or a similar defense conference which the prosecution had. I mean, so that we will discuss the way forward on how we shall be presenting our case to the court. It is just prudent that in view of the fact that the prosecution has at least led 18 witnesses over a period of 1 year or so, that we be given at least a reasonable time. Equality of arms demand that we prepare our defense well to the best of our ability, and to also be able to receive clear, undiluted instructions from the clients, so that they will know what they are doing, and at least they will be able to stand their defense in the manner in which they believe they can. So, respectfully, in view of that, and in view of the time spent, before putting the case to the defense, that in our case, the first and the third appeals, they give us a week. So, engage them. Because we have to put the pros and cons of every count to them so that we understand. It is possible that they want to say something in one and not say it in another. On the other. So, that is our position for now, and we are doing it with all respect and indulgence to you. To understand that they have all along listening to the case of the prosecution and trying to cross-examine their witnesses. It is now their case, so we must have sufficient time to prepare the case. And also to also have conference with the court and the prosecution, so that the prosecution too can understand how we want to present our case. You have seen opportunities for the we've had conferences in chambers of the judge. No, it's definitely conference. But in any case, that is I'm sure we'll have friends for the other businesses.
The first thing I'll say is overlay this. That every council knows that when you put in a notice submission in accordance with the relevant test, there can be one or two outcomes. And council is fully aware that where one outcome fails, what the options are that are available. And I go back to Mr. Gebal at the time when he was cross-examining. He was fully aware what he wanted to do at the time the prosecution was seeking to close the case. So I do not accept that council do not know, or they want a lot of time in order to advise the client as to one or three elections. You've been cross-examining extensively over 18 witnesses. I dare say that you are fully grasped with the prosecution's case to the extent that brilliant notice submissions were made, but for the legal tests applied in these cases, those notice submissions may well have succeeded. So time is something that we do not have a luxury of. Again, we have sufficient time to deal with the question of election, because as it is, if you recall, the discussion that we had prior to the close of the prosecution's case is that after the notice submission, we will proceed on the locus. And I'm going to be seeking to do that next week. So we can deal with all of that. So effectively, that gives you enough time to prepare whatever defense or whatever thing you want to do, or the manner in which you want to carry out your defense, once we proceed to New York and come back. And at that stage, Mr. Masibo will have an opportunity to determine whether he needs to recall witnesses, or in fact, the defense counsel will also have an opportunity based upon that locus to determine what they want to do. But essentially, what I'm not minded to accede to is just granting a brief adjournment to decide which election to choose. But I don't think that
I got the last bit of your statement almost answered that, because when you said that perhaps sometime next week you will entertain us to look at, because if he is still minded to call witnesses,
he's minded otherwise is subject to the local visit. Because he might well go to the locals and say, no, I'm happy with my case, I'm not going to move for him. So that was what we had discussed, and that was what was in the previous orders of the delegate.
So in essence, that would be material time that then they should be put to their election.
No.
As a matter of fact, questions about the locals might reopen issues.
No. Mr. Foreman, the locals is part of the case, yes, but we were very clear that if you go back to the orders that they gave us to what we are going to be doing at the locals, you have put questions in cross-examination to witnesses, which are essentially tended to cast a light on the defense's case, which I fully understand. The question is simply, am I going to call witnesses? Am I going to rely on my statement, or am I going to testify? That is not to say without prejudice that an accused person cannot again upon reflection decide that, well, I said I was going to call witnesses, but I've changed my mind in light of what I've seen.
But the locals will definitely
No, the opportunity will be given for accused persons to change their mind if they so desire. But what I don't want to do is just give a whole week's adjournment just to decide which way I'm going to go. Then we come back, we go on the local visit, then we say, if I change my mind again. So we get over this aspect of the case, so we're clear on the basis of the evidence as it is, because if Mr. Masibo comes back and says, I'm not going to do anything, I'm happy, then we continue. But time is not of the essence. And again, this case has taken a long time.
So, before, I'm sure Mr. Kabo will want to say something, but before I sit down, just to be a little bit clear on that, is it therefore the case that if we are put to our election, for example, I'm saying that I need instruction, but if that happens, and then Mr. Masibo comes back and says, wait a minute, I still have witnesses that I need to record based on the local receipt.
What's wrong with that?
No.
Don't get confused. I have not said, neither am I saying or implying that once you put your election, you start your defense now. No, I'm not saying that. What I'm saying is that the law requires that at the close of the notice submission, the accused persons are put to their election. That needs to be done. Now, after that is done, next week, the time that we still want, we'll go to the local visits in New York. And upon our return, depending on what Mr. Masibo intends to do, the accused will then be in a position to put their defense, to start the defense of the case. So the 1 week that you're asking for, you're going to have 2 weeks. But what I'm not going to have is 1 extra week and then 2 weeks. That's the problem.
Still something just to clarify. There we go.
Sure.
I mean, my Lord, the reason why I believe Mr. Masibo has not totally closed, I would say, because he has not exactly, we made a low case submission, but it was premised on the fact that he may come back to the court following the local visit and probably 1 or 2 considerations.
I captured that in the notice submission that at the end we were all agreed, all defense counsel will agree that should Mr. Masibo wish to reopen his case, he'll be allowed to do so. And once he reopens his case,
if you want to make further no case submission based on the
no, there can't be a no case submission. No, hold on. The local submission is relevant to the prosecution's case and your defense, not to the local submission. The local submission is made on the strength of the prosecution's case, which is not an issue. But whatever happens in New York could affect one way or the other the prosecution's case and will be relevant to your defense as well. So this is where we are. But we cannot have a situation where we're just taking time off to think what we want to do. In fact, enough time to think.
You like to philosophize like this. If I give you a scenario,
for you to be able to put together the number of witnesses. Yes, Madam.
So you know who is going.
I crave your indulgence for a date, even if it's not the 1 week adjournment that is requested. I will need time to actually handle have a total resolution.
Wait a minute. I mean, you guys, hold on. You guys were given an opportunity to speak. You spoke your hearts out. That is his view. That doesn't mean that I buy his view. Why are you all up in arms?
Mr. Maximo.
No, but that is his own view.
But your Lordship, I want to caution you on the sort of language you use in this place, my Lord.
No.
I know English is not your first language.
Mr. Kago.
Yes, my Lord.
Mr. Kago.
My Lord.
You know what? Look, allow him. He's got his own view. Let him say what he wants to say. I'm listening to him. That doesn't mean I'm going to accede to what he says. I'm not listening to him.
My Lord, I won't take issue with I would call it a practice of my learned friend to interrupt counsel when he is speaking. I don't think, my learned friend is fairly senior. He knows how these things are done. You don't just stand up. You are given an opportunity to respond at an opportune time. But that said, my Lord, I won't be deterred from making my point that what is being suggested will amount to further delay in the resolution of this matter. My Lord, if counsel had taken your suggestion to heart and consulted, by now the election exercise would have been completed. We are not, as I understand, they are not being asked to indicate how many witnesses they are going to call, maybe so, but certainly not to lead any evidence. So clearly, it's simply saying we are going to put the accused on the stand, or we are not. That is not something that requires any substantial amount of consultation. None of my learned friends, with all due respect, has proffered a reason as to why they require a period more than what is available to them. Yes. My Lord, I still make that point that this matter now cries out for resolution, given the amount of time that has already been spent on it. And more significantly, my Lord, given what my learned friends are referring to as the prevailing circumstances. The sooner this matter is resolved, the better. And for that to happen, we have to utilize each and every moment that your Lordship has at his disposal. Your Lordship has got almost always a full docket. Afford us the time to proceed with this matter. My learned friends should be grateful. Yeah. So, my Lord, without belaboring the point, it's not an empty statement when people say justice delayed is justice denied. This is precisely the circumstances where it comes into operation. Doesn't matter where it's coming from. For as long as the point is made, my Lord, that rather the court does all in its power to avoid delay in the resolution of the matter. So my submission, my Lord, would be that just as the prosecution was constrained, if my learned friends' memories are clear on that, the prosecution was requested against what is considered better judgment to close its case. and that required a much more substantial exercise, because when you look at evidence and come to a clear decision, that will step by this. What they are being asked to do right now does not demand anything at all, rather than an indication to your that we are taking this route, we are taking this route, that's all. We are taking this route. That's all. And they can change it. They can change it. The circumstances demand. So my lord, I would submit that there be an adherence to direction, and accused be asked to make in the event that for whatever reason ought to be a delay. We respectfully suggest should it be convenient to the court, resume tomorrow morning for them to make their election. But that is a concession. That is made in the event that for whatever favor, without submission that we have the election right now before we adjourn. That is all.
Wants to address the Lordship.
There's nothing more you can say than you. What do you want to say? With your leave and permission. What do you want to say? With your leave and permission. What we want to say here is we have the optics here. We have the official proceedings being covered last. This whole proceedings is being covered. Our learned friend here and our learned friend here has been insinuates that we have been that we have been. The Lordship gave an order. The Lordship gave one order. This matter to finish in record time of the prosecution. The provisions of the prosecution are not done in terms of the orders. Last of them all was the order that you gave submission. The response to the Lordship submission to this court. By January 24th, by January 20th, applications are in. All responses are in. They asked for an extension of time to January 31. And then that's the time they came. And we commended the Lordship. In able to do 3 weeks. In able to do 3 weeks. However, the Lordship has given the Lordship has given the detailed submission. We know the choices available to us. That one, they can choose. That one, we can choose to even change our opinion and say we are guilty. We can change our opinion to say we are going to testify. Yes, but we are going to testify. But testify from the door. We are going to testify from the witness stand. We are going to testify because of that stand. And because we are going to testify, we are going to testify. We are going to call the status indicated. The status has changed. The fourth accused person is not only standing here as the fourth accused, but is also the leader. But is also the leader, also to an order of this, and being the leader of the Congress Party, whatever advice as lawyers, whatever advice as lawyers, to take into account what we have to take into account what will be himself and the party himself. And so we cannot now just come and sit here and say, oh, he has to sit here and say, oh, he has to give us 10 minutes to testify, give us 10 minutes, want to tell whether he has to testify, or whether he has to testify, or whether he has to come witnesses, or whether he has to. We cannot shut our eyes. We cannot shut our eyes that the judicial notice like that for political protest. So as lawyers, because whatever public interest involved, so based on that, give us a let us revolve our clients. Let us know which kind of election, which kind of election. Then once that's done, then we cannot go before the court. Then the court cannot go before the court. When the court directs to start to when each defense to start to we are saying because we are saying because the judicial change of the nature, which has changed the court of time. Because this matter has not become a matter of politics. It's no longer a matter of it's no longer a matter of Kamara, but it's a matter of Kamara. But it's a matter of because whatever whatever each upon the outcome of 2023 elections that we have to follow. So because of that we have to follow. Actually because of that to grant us the time so that to grant us the time show to our client, show to our client decision and what decision what we will achieve as to the election of what happened. As to the election of what happened. That's what I'm talking about. All right, look. You talked about the public interest. I have to look at the public interest. And I'm going to look at his to have this matter out because it will be most unfair for this matter to be going on elsewhere while he's focusing elsewhere. And I certainly would not be doing that. This matter, as far as Mr. Kagbo, as far as Mr. Kagbo is presented circumstances, we're not shutting our eyes for you. This is not shutting our eyes for having gathered to what is happening. That's it. I bear in mind by Mr. Argument by Mr. I have built it protection. In line with section 23, in line with section 23, to ensure the trial is not prejudiced in any way, shape, or form. If you remember my starting point, I said I needed to have a better plan, better plan going forward. The trial to make sure we don't get into a situation where extended bits of time, because at the end of the time, whatever extended the matter is still hanging. The matter is still that issue that is of concern to me, that matters of concern to me, that the matter should be hanging. Somebody going for such